So, this video, Nick, will be a little bit lengthy, but let's analyze things. So, first off, I know you talk about how you disagree with Yusufel on it's all commerce. Well, it may not be all commerce, but the majority of what's going on, it is all commerce. There's very little that doesn't fall within commerce. And I will show you a piece of evidence shortly. But first, we need to show the evidence on what I'm talking about. So, you see right here, Article Three's case and controversy distinction and the dual functions of federal courts. Okay, there's two functions. That means depending on the function will depend on what jurisdiction they're operating in. And you know as well as I do that a lot of these people out there that listen to the wrong teachers, they run around saying it's all law of the sea, and I've proven that inaccurate numerous times. But that doesn't mean it is not under admiralty jurisdiction. So let's go to a little footnote and look at what they say. Now, let's look at this. Maritime law is not the law of a particular country, but the general law of nations. In other words, international law. Now, what are the states? The states are, quote unquote, sovereign nations. Maritime causes generally depend on the law of nations. Wilson's work, Supra 75 at 279. Another branch of the law of nations, which has become peculiarly important by the extension of commerce, is the law maritime. Now, who actually gets to regulate everything that is in or has an that moves in or has an effect on interstate commerce? Wouldn't that be Article 1, Section 8, Clause 3? That would be Congress. So this is the footnote for Admiralty Maritime, as Admiralty had been one of the few areas of national judicial concern during colonial, revolutionary, and Confederation times. Article Three's extensions of judicial power to all cases of admiralty and maritime jurisdiction. Now, what is an and? Wouldn't that denote two similar things, separate yet uh, and distinct, possibly? In other words, they fall under the same category, but you've got contracts in commerce over the land and you've got contracts in commerce over the sea. So, coming from that standpoint, there can be a criminal jurisdiction under admiralty jurisdiction. Now, let's look at another piece of evidence from Harvard. When I saw this, it blew my mind because I had been saying this exact thing long before I took this class. Let's see. Yes, it is a federal case because being on the high seas, it comes under something called the admiralty jurisdiction, and that's always in federal court. The admiralty jurisdiction is governed either by federal statute or by something called federal common law. The federal common law of admiralty, which is the federal common law of contracts. So any contract involving commerce that can be on the land or the sea is under admiralty jurisdiction. I am a truck driver. I picked up a load today in New Jersey and I delivered it to New York. That's between two nations, and the federal government has the exclusive right to regulate commerce. That's why the trucking industry is federally regulated. Now, let's look at another piece of evidence. Now, let's look at this plea agreement. And yes, me and you do agree a plea agreement is a contract. It has all the telltale signs. Not only that, it has the language. But I want to show you something. Right here, count 2. What does it say on line 4? That the possession of the firearm charged in count 2 of the information was in or affecting commerce. Now, why was that? Let's look here, paragraph G. The firearm listed in count 2 of the information knowingly possessed by the defendant on May 25, 2022, was not manufactured in New York and therefore moved in or affected commerce at some point prior to the defendant's possession. See, they don't come right out and tell you it falls under admiralty jurisdiction all the time, but the legislature has all the exclusive authority under Article 1, Section 8, Clause 3 to create criminal acts under admiralty jurisdiction, which is based on contracts that are in commerce. Now, let's look at a court case where the Supreme Court kind of alludes to this. They actually don't 100%. They don't fail it, so to speak. And I put a video out on this, and it goes back to the very first document I showed you on the cases and controversy document at the beginning. The Supreme Court has a dual role. Okay, Article 3, they don't have jurisdiction over Article 1 courts or Article 2 courts. They have a very limited scope. So now, let's go look at a court case that admits that. This is Federal Radio Commission versus General Electric Company, 281 U.S. 464, 1930. Now, let's look at this section here. In the cases just cited, as also in others, it is recognized that the courts of the District of Columbia are not created under the judiciary article of the Constitution, but are legislative courts. Wouldn't that be Article 1, Section 8, Clause 9? The inferior tribunals that was created by the legislature. See, this goes all the way back to the founding of the country with the Judiciary Act. Okay? The legislature created courts also because why? They had the authority to. And therefore that Congress may invest them with jurisdiction of appeals and proceedings such as just have been described. So if you appeal to the United States Supreme Court, are you going under Article 3 or under Article 1? Just a thought. But this court cannot be invested with jurisdiction of that character, whether for what character? One of the characters was appeals. Whether for purposes of review or otherwise. It was brought into being by the judiciary article of the Constitution, is invested with judicial power only, and can have no jurisdiction other than of cases and controversies falling within the classes enumerated in that article. It cannot give decisions which are merely advisory, nor can it exercise or participate in the exercise of functions which are essentially legislative or administrative. That would be courts under Article 1 or Article 2, because the executive branch has courts. The legislature created inferior tribunals under Article 1, Section 8, Clause 9. And see, this is also alluding to the separation of powers doctrine. Then, under Article 1, Section 8, Clause 9, they created these administrative agencies that has administrative courts that are not judicial. They are either under their ministerial capacity or their quasi-judicial capacity. So, and the administrative agencies all have administrative courts that fall under the executive branch, because under delegation of powers, Congress gave that power to the president, the executive branch. And do you think this is just federal? The states followed suit. Give you an example. Department of Health and Human Services, what do they have? Family courts. Internal Revenue, what do they have? Tax courts. Department of Transportation, what do they have? Traffic courts. I can go on and on and on and on. See, Nick, I don't have time to go over all the evidence of this stuff in a video. There is so much evidence that I've read, and it's why I say the things I say. But you got to open your mind to the possibility, because see, I go back through the history and read the historical documents of what has been set up. And I've asked every attorney I've asked this question to: how can you truly know the system you are working in if you do not know the history and how it was developed? They don't always teach you that in law school. You got to learn that on your own. And that comes with tenure. So, you may disagree with this, and that's fine. That is your right. But I'm going to share it so that way you can see where I'm coming from in part.